Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Robert S. Bernstein discusses executory contracts.
Executory contracts are a creature of the Bankruptcy Code. They're not created by the Bankruptcy Code, but under Section 365 of the Bankruptcy Code, the Bankruptcy Court can change contracts, can change the expectations of the parties. And one of the ways it does that is through Section 365 and the ability of the debtor or the trustee to assume or reject, live with or terminate executory contracts. So what's an executory contract? An executory contract is a contract with duties yet to be performed on both sides. Typical executory contract is an open purchase order. You send me a purchase order to sell you 1,000 widgets and you'll pay me $1,000. At that moment, we have an executory contract, assuming I've accepted that purchase order. We have a contract. I have the obligation to ship the widgets, and you have the obligation to pay. If, on the other hand, I've already shipped the widgets and invoiced you for $1,000 and you haven't paid me, that's not an executory contract. I'm already finished. There are only obligations on your side, which is the payment side. That's just a debt. But we're talking about executory contracts. Leases of equipment or real estate are garden variety executory contracts. I have the obligation to pay you rent. You have the obligation to give me possession of the premises from month to month. One of the important things about the Bankruptcy Code treatment is that the debtor gets to decide whether to live with it or not. If it is beneficial to the estate, the debtor can decide to keep that contract, even though it's in default, can keep it and live with it through the bankruptcy, especially in Chapter 11. A debtor in Chapter 11 could live with a defaulted real estate lease on through the bankruptcy. But when the debtor assumes a lease, it must cure all of the defaults, including pre-petition payment defaults. So if the debtor is delinquent on the rent but decides to assume the lease, among the things it has to do to assume that lease is it has to cure the defaults. And that, of course, is beneficial to the landlord, lessor, the creditor. If the debtor also has to show that it can adequately perform in the future, because it's now taking this obligation on anew, and the creditor or the landlord shouldn't have to take additional risk. The debtor can, in some cases, assume an executory contract and assign it, actually sell it to somebody else. So if the debtor happens to have a below market lease rate on valuable property, the debtor can find somebody who wants to be in those premises and can actually get paid cash by the buyer for an assignment of that lease. Has to cure the defaults and has to show that the buyer, the assignee, would perform in the future. But it's possible to have that assignment and recognize the value, treating the landlord fairly. If the lease is rejected, it's treated as though it were breached the day before the bankruptcy. So that, in fancy terms, means that the claim that results from the breach is a pre-petition unsecured claim. So if you're owed $1 million in rent for the next year and the debtor decides to reject your lease, your damage claim is going to be a pre-petition claim which can be paid cents on the dollar with everybody else. So it can be, it's a way of the debtor freeing itself from this obligation, or if it chooses to assume it and take on this obligation, it has to cure the defaults. The deadline for assuming or rejecting is different depending on whether it's in a Chapter 7 or in a Chapter 11. They're much shorter in a Chapter 7, and they're automatically rejected if not assumed at certain points. It's important to check those deadlines with the Bankruptcy Code depending upon the chapter you're in, or check with your counsel.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.